Jamie Miller from the Miller Law Chronicles Podcast. Today we have a special guest, Nathan DeLadurantey of the DeLadurantey Law Office. Nathan today is going to join us and talk about repossession law in Wisconsin. Essentially what you need to do when you are in default on your car payment, and if your car loan was more than $25,000, how to handle that, and also how to handle if your car loan was less than $25,000 and you get one of those right secure default letters. We'll talk about how to handle those. We'll also talk about how to handle repossession lawsuit when the lender's coming to take your car. I appreciate you listening in today, I think, and I know you're going to find this really valuable. If you enjoy this podcast, and I hope you are, please like us on Spotify and subscribe to us on Apple Podcasts and Google Podcasts, YouTube, TikTok, wherever you see us. Anything you can do to show a little thumbs up for us, we greatly appreciate it. It will allow us to continue to bring you amazing content. Thank you so much, and we will look forward to speaking with you soon at our next podcast. And I'm excited to welcome you to another edition of the Miller Law Chronicles Podcast. Today, I'm really excited. We have a special guest in Nathan DeLadurantey, who's going to talk today about auto repossession in Wisconsin and problems and issues that our clients met with, perhaps before they file for bankruptcy, but in situations where people fall behind on their car payments and just need some advice and words of wisdom of how to deal with that. So Nathan, thank you so much for joining me today.
Glad to be here, and thanks for having me on.
This is awesome, and I really appreciate you spending your valuable time. And you and I have been working together for many years now, and in particular, you handle for us a lot of situations where find themselves dealing with creditors that violate Fair Debt Collection Practices Act, that violate the Wisconsin Act. Tell me a little bit about who you are, what you do, your area of practice, and all that kind of interesting information.
Sure thing. So my practice area is in what we generally call consumer law, and it covers a wide range of things, anything from identity theft to credit reporting, and then lots of cases involving vehicle repossessions, both the actions that occur during a repossession and things that may be happening before or after that violate different statutes. My office is out in Waukesha, and I live out in that area with my wife and 4 kids. And when I'm not suing creditors or repossession companies for violating the law, I'm exploring hiking trails out here or just spending time out in the great outdoors.
That's great. I appreciate it. So have you been practicing in Wisconsin for all of your career? Where did you go to law school?
Small school in Fresno, California.
Right.
Don't take any cases outside of Wisconsin at this point. I've had cases from the Southern District of California to Florida. But these days I stick tight to cases here in Wisconsin. Plenty of it to go around protecting consumers.
I know that you have a real solid history and experience in doing a lot of bankruptcy law. So what's really wonderful for our firm in working with you is that we all speak the same language, and I've always appreciated that. But what I wanted to talk about today was auto repossession in Wisconsin, and what's the governing law that governs auto repossessions and those types of issues here in the state of Wisconsin?
So Wisconsin, we have 2 different statutes that could potentially govern a repossession. And it's dependent on the dollar amount financed in the transaction. So, you go to purchase a car, you're filling out all this different paperwork, and you get to that section that says amount financed. For loans that are amounts financed that are $25,000 or less, it's a body of law called the Wisconsin Consumer Act, or in the acronyms we lawyers like to use, called the WCA. If it's over that dollar amount, it's going to be a different statute called the Uniform Commercial Code, or the UCC. And so that's the great dividing line. There are different right and remedies that exist under those 2 different statutes that are different. As we move through any questions or different things that we'll talk about today, I'll try to tease out some of those nuances or differences between those two statutes.
Let's say someone has a car that they finance for over $25,000 and it's being governed by the UCC, and they've fallen behind on their payments, and the lender is contacting them. What should they expect? What would the process be on what they might hear from that lender for cars that are financed over that $25,000?
So in that situation where the amount financed is over 25,000, once that loan moves into default, in other words, that term default is going to be governed by the documents or the loan documents that are in the transaction. Once they're behind, that repossession can occur without any warning at all. And so let's say, for example, your payments are due every 30 days. There's a 10-day grace period, but you're 2 months behind, so 60 days. That lender, without any further notice, can come out and repossess that car without any form of a court order. And so that's the big difference there on those types of loans. Again, over 25,000 versus loans that are under 25,000 be governed by that Wisconsin Consumer Act.
I still see, even though lenders can exercise kind of self-help, they don't need to go to the courts. They can, if it's in default, they can come take the car with no notice. Maybe it's just me, but I'm still seeing those lenders sue for repossession, or is that not the case, or what are you seeing out there?
It's a good question. And it's a little bit lender dependent and then changes over periods of time. And so we'll tease it out. So let's say that a lender, we'll call it ABC lender, could go and exercise a self-help repossession. What will end up happening is they still run that risk, right? That they could have some form of an encounter or something go on during the act of the repossession that may open them up to liability exposure. If they go to court and get a writ, an order from the court saying you can go out and repossess this car, they can have the sheriff go out and do it. And it can potentially reduce their liability exposure. And I think that there's a lot of wisdom for lenders who do that.
Are you seeing many lenders that they're exercising self-help and are coming and taking vehicles without the RIP-11 if the car is over 25,000?
I think in the vast majority of cases, regardless of dollar amount, we see a self-help versus filing for a RIP-11. And the reason being is it's a lot faster, right? If somebody's going to
Right.
go and seek a court order to repossess a vehicle, they have to file a summons and complaint. The person has to get served. And then I think, frankly, there's just a lot more opportunity for that consumer to try to exercise different rights. And one of those could be a bankruptcy to prevent that vehicle repossession from ever occurring.
Just to confirm so that people understand, is that if you financed your vehicle for $30,000 5 years ago and you only owe $6,000 now, they're looking at the amount financed, not the current balance.
Correct.
This is very important. The other thing is, I'm noticing that more lenders are placing GPSs in vehicles that are financed. Can you speak to that a little bit?
You're spot on. We're seeing a lot more of that. And we often hear this conversation, right? Somebody's like, I've had the vehicle, I've moved, I have no idea how they found me. I think there's a tracking device on my car. Sometimes that's true, but interestingly enough, there's something else that goes on that has nothing to do with a GPS device. So repossession companies, they engage and they use a product, and we call it LPR, license plate recognition. And it's what it is. There's camera cars, and like Google, who drives around and creates Google Maps. That there are vehicles driving around that are scanning license plate and creating a database tracking basically the habits or the locations of vehicles associated with that license. The repossession company can go in, type in someone's license plate, and it'll give them idea of where it's located, how often it's at different locations, different driving trends. So maybe it's dropping off at daycare, going to a gym, going to work. And for the consumer, it can feel like they're being tracked, but actually what it is, it's their license plate that's being recorded as these different cars go around towns and can locate.
The license plate tracking, they probably don't need the permission of the borrower to do that. The GPS tracking device is part of your agreement. You may not have a choice, but they're going to put that in the agreement that, listen, when you sign this agreement, you understand there's a GPS tracking device.
Correct. Everybody that I've seen that's using them, with one or two exceptions of perhaps super small dealerships that haven't thought through their regulatory or compliance side, have used them, but everyone else, you see a common disclosure that says, you're aware we have a GPS tracking device. We're using it to monitor your location. That's fairly common with some lenders.
Are you seeing any movement? The $25,000 level for differentiating between the Wisconsin Consumer Act and the UCC seems low with the way cars are priced today. Is there any movement to push that number up?
There's not currently. That number's been in place since the mid to late 70s when the Wisconsin Consumer Act was passed. So obviously, given the rate of inflation over the past almost 50 years, that $25,000 does not buy you much car. There has not been any push to amend. There was a push about 3 or 4 years ago to make some changes to the Wisconsin Consumer Act. Those were passed and then ultimately vetoed. Those proposed changes were extremely unhelpful for consumers. So grateful that did not ultimately end up going through.
Now, let's change the conversation to vehicles that are financed below $25,000. And as you said, it takes us into the Wisconsin Consumer Act. Let's presume the borrower is in default according to the terms of the agreement. And if they are in default, what are the steps that the lender has to take to get that car back?
This is great because the Wisconsin Consumer Act is one of my favorite bodies of law, so I will try not to gush too much. So we'll start first at the beginning about this idea of default. So default is defined under the Wisconsin Consumer Act, regardless of how it might exactly be crafted in the loan agreement. But the borrower needs to be 40 or more days behind on one full payment. Once that occurs, again, so let's assume that your payments are due every 30 days and they're $200. You need to be more than 40 days behind on that $200 payment on whatever interval it might be before, under the Wisconsin Consumer Act, you would be deemed to be in default. However, once that moment occurs, or the lender believes that moment has occurred, before they can treat the loan as in default, they have to send out a specific letter. And that specific letter is called a right to cure, C-U-R-E, right to cure. And it's just as it sounds, and it's a letter from the lender. Both the contents and the timing of that letter are very carefully regulated. And essentially what it has to do is give the consumer an opportunity to cure that default before the loan can be accelerated, before a repossession can occur. And that's a crucial moment, right, for any borrower, where the lender's saying, hey, we think you're behind. You need to get these funds to us and get caught up. And that letter, before anything bad can happen, we'll talk about repossessions in a few minutes, it gives them 15 days to get caught up on that loan. Now, here's the kicker. That part of the statute is written in a really unique way. And the first part of that it's unique is that the lender is only required to send the notice. They have to send it via certified mail. It does not have to be received. So let's say, for example, you don't pick up your mail from the post office. You get that little slip on the door saying you've got some mail, and you just don't go to pick it up. That doesn't change the lender's right, because the law only requires for them to send it. Let's say that the post office picks it, or loses it rather, after they pick it. That doesn't change it because the lender's only required to send it. Let's say that it gets delivered to your neighbor and your neighbor never gives it to you. That doesn't change things from the lender's perspective because they're only required to send it. Tied into that is this part is that the lender is required to send it the address that you had listed when you first applied for financing, unless they have reason to know or you've notified them that you've moved. And here's just a tip for everyone. Most folks move and they tell me, hey, I changed my address with the post office. You need to do something more. You actually need to reach out to the people that you have loans with and let them know that you've moved. Now, I know some people are concerned, well, I knew I was behind. If I told my lender that I moved, I'm concerned they'll know where my car is. That takes us back to the earlier part about license plates getting tracked. Your lender's going to find your car even if you don't update your address. So get it updated. Keep it updated. That way you know when your vehicle's at risk of repossession.
Hopefully they get that right to cure default letter, but if they don't, they're going to find a tow truck perhaps at their door and be surprised, and their car disappears. And they say, I never got notice. And they call you, what do you do? They say, my car got repossessed. I didn't even know that a right to cure default letter was set up. Is there anything that you can do to make sure that the lender proves up that they actually sent it?
So in those situations where somebody's car was repossessed and they're saying, hey, I didn't get that letter, what I encourage them to do is just call up the lender and ask for it, right? Every reputable lender is going to have a copy on file. It's going to have a USPS tracking number on it, so you can make sure that it was actually sent. Very often what we find out is lenders did send it, right? And somebody didn't update their address or they didn't pick up their mail. But we still see a fair number of situations where it wasn't sent. The other thing that we see and why getting copies of that letter, whether it's from the lender or from the borrower themselves from the records, is there's that timing component, right? That 15 days that I talked about. But there's also a content notice, meaning that the contents of the letter itself are also regulated. We've done a wide variety of cases about the content of those notices being off. Because tied into that 15 days, that right to cure, lenders can marry with it the second part of the statute, which is we think you're behind. And then two, if you don't get this thing brought current, we're going to exercise that right to go do that self-help repossession. So we have these two different parts of the statute, time to cure and that notice of an intent to repossession. And the law allows those to be put into the same letter, which is what we see in virtually every situation.
So if someone gets that right to cure default letter, what should they do with it?
So first up, you can read them. And when you read through them, you'll see it says you've missed, let's say, for example, your January and February payment. You owe us X amount of dollars by this date. And typically below that, you're going to see this language where it says you've got these 15 days to make this payment. In that section, it's also going to say, if you don't get the loan brought current, we have the right to come get your car. And it'll say, if you object to our exercise to getting your car coming out, that self-help repossession, you can write to us in that 15-day window and demand that we take you to court before we can repossess the vehicle. And it'll also say, if we go to court, you may be responsible for court costs and attorney fees, which in a small claims case is a couple $100, usually relatively minor. It's not the actual attorney fees, right? They can't go hire a high-powered law firm that's going to charge you $20,000 on this case. It's statutory attorney fees. Again, a couple $100. If a consumer gets that letter, they're concerned, they think that there's been misapplication of payments, they don't want their vehicle repossessed, they can write to the lender. And there'll be an address on that letter and say, no, don't come for my car. You take me to court. And the lender must take them to court and cannot go and repossess the car at that point.
What if they get the right to cure default letter, the lender is correct that they are in default, they know that they're behind, but they need more time and they need more time to get caught up and the lender's not cooperating? What can they do?
So in that situation, the way the law is written, the borrower, the consumer, does not have to provide a reason for telling the lender to take them to court. This isn't a moment of confession. They don't have to lay all their cards on the table. All they're required to do is tell the lender, no, don't come take my car, take me to court. If whatever their motives for that might be, they don't have to spell that out. They're allowed to make that very simple and clear request. Now, I tell people, when you send that letter back to the lender, send it with a tracking number on it. Because if you get into a dispute, if the lender doesn't follow the law, we want to be able to march into court with a receipt from the post office and a tracking number to say, you got our letter. You broke the law. You didn't follow the law. You're operating in Wisconsin. The borrower has to follow the rules. The lender has to follow the rules. And we want to be able to prove to the court who messed up.
What about the timing? So I get the right to cure default letter, and I presume I can't email the lender or fax the lender. It has to be sent via mail. Is that correct?
That's correct.
And what if I send it out on day 14 and is it 15 days to get that objection in and it arrives 18 days? What happens there?
I go by the postmark on the letter. I don't think that there's a shred of case law on it. What I will say is that lenders typically wait, right? Because we're going to have that whole idea of 3 days for the U.S. mail to presumably deliver a letter to someone. And you'll usually see baked into the letters that kind of language, right? It'll say, you need to let us know by a date certain. There's usually that additional time. If you're close, that's where overnight delivery's for, right? Maybe it's going to cost you $20 to send in that letter, but that may be the difference between keeping your car or not.
So sending it certified, keeping your receipt, making sure you can document that. Now, why in today's world won't they accept fax or email? It's just the nature of the statute.
Yeah, and the statute's written in the 70s. There's different portions of the Wisconsin Consumer Act that you can tell just in reading it when it was drafted, because there's no presumption of the internet at all. We're talking mid to late 70s. That wasn't a concept that people were even thinking of in both an advertising and a sales component. And hopefully sometime while I'm still practicing and alive, we'll see technology get upgraded and integrated into the statute, but not for now.
Is there any advice you have for borrowers as to what language they should contain in that response?
Short and sweet. I object. Take me to court. That's it. There's no magic language.
So they get the right to cure default letter, they get the objection in timely. What's going to happen next?
So they're going to sit back and wait, right? We've got this decision tree at this point for the lender. They can do one of two things. They can go and take the person to court, which is what they're required to do under the law, or they're going to mess up and go out and repossess the vehicle without taking the person to court. And so obviously the right option, the legal option, is to take the borrower to court to repossess the vehicle. We still see instances where lenders get those letters. There's tracking numbers. They tell the lender, no, you can't take my car. You have to take me to court. And guess what they do? They go out 3, 6, 10 days later, and they yank the car from the person's driveway in the middle of the night. That's an illegal repossession under the Wisconsin Consumer Act.
Who wins in a situation where the borrower sent it out on day 14, but it didn't get to the lender until day 17? So we have it postmarked in time, but then lender goes out before they actually get the letter and repossesses the vehicle. What happens in that situation? Is there a claim on behalf of the borrower?
I would bring that claim. I've not had that presented, and I don't think that there's any case law on that point. But if the postmark was still within that time period, I think that person is 100% okay. That's a case where I would definitely sue the lender for an illegal repossession.
And then I get this question from borrowers and clients all the time. Can they take the car out of my garage? Can I hide my car? What can they do if they either didn't respond to a right to cure default letter, or perhaps they have a replevin judgment against them and they know the lender's coming for the car?
Those are great questions. We'll break them down. One of the most common questions, I think most highest read article that I've ever written on my website is, will I go to jail if I hide my car from the repossession? And the answer is no, you can't hide your car, right? Hiding collateral to prevent a repossession, don't do it. It's wrong, and it can get you in a world of trouble. Now, hiding your vehicle is very different than living your life as you normally would. Repossession agents cannot go in garages. They just can't. It's not allowed. And it's a safety reason, right? Garages, whether they're attached or detached, they're connected to your residence. And the last thing the law wants to allow is for people breaking into homes to get stuff. And it's just a safety decision, right? We don't want people getting hurt. We don't want people thinking it's a burglary or a robbery. And we want to create these very bright line standards to protect people. Now, they can come into your driveway. They can come into the parking area behind your house. They can come into a shared parking lot. They can do all these things. We're not talking about the great outdoors. We're talking about structures. And so that's an important thing. They can't open a garage door. They can't open an unlocked garage door. And I'll give you an example. They can't move something else to get to the collateral. So let's say, for example, you're double parked, right? I park my car. It's a 1-lane driveway. I park my car in the front. You park your car behind me. We're watching a movie, having dinner, out for a walk, hanging out with friends, whatever it might be. And the repossession agent comes by and he sees that my car is parked in there. And he thinks to himself, I'm going to take Jamie's car, hook up my tow truck, scoot it out of the way, get to Nathan's car, repossess that one, and then just put Jamie's car back. And that's a no. You can't do that. That's going to get the lender and the repossession agent sued.
As we go through this process, lawsuit's been filed for repossession and the borrower's not represented. What's the best thing for them to do once they get sued?
It's a tough one, right? Because you're going to be in front of a court and you're going to have to show that there was some defense that they have to the case. And I'll give you an idea of some of those common defenses. Number one could be you were current on payments. Maybe the lender misapplied them, put them on someone else's account, didn't properly credit them to your account on time. Now, those are infrequent, right? Seen them on occasion, but it's very rare for that. Other instances could be that you have valid defenses to the enforcement of the contract itself. These aren't super common, but I'll give you some examples. I've been working on a case. The lender was not licensed to do business in Wisconsin, right? or a state that requires certain lenders to be licensed in certain circumstances. If the lender is not licensed and they're required to be, you have an absolute defense to the collection or enforcement on that contract, right? They've sued you for it. You've got a valid defense. These are rare ones, right? Most of the time we see lenders that are properly licensed. Somebody fell on hard times, sickness, job loss, divorce, the things that we see every day. Unfortunately, the court has to look at this in black and white, right? You have a contract and a promise to pay. You might be going through something that's just utterly soul crushing. Maybe the court will give you a little bit more time, but without some hard evidence of payment misapplication or other lender misconduct, that court's going to let them come for that car and give them the order to do so.
Got it. And then seeing more and more clients take out auto title loans on older cars that they may have. Do any different rules apply to them when it comes to right to your default letters or repossession lawsuits?
No, same structure. One of the things that you sometimes see, though, is that, and comes and goes in waves, is often those right to cure letters are sent out by a local office versus a central office, let's say, for example, a national lender. There is a higher likelihood of a mistake on those right to cure letters at a local office versus a national one. And it's just a size and compliance issue. It's entirely hit or miss. But when I see that, I think to myself, there very well may be a problem.
Can you give me the top reasons why somebody should call you? Like when it comes to repossession or falling behind on their car?
There's a couple of, I'll give you kind of the top ones, right? And when somebody calls me, and they fall into a couple of categories, one, which is my car's been repossessed, right? Car's already gone. I woke up this morning and it's just missing from the driveway. My first question for them always is, during the repossession, did you have any interaction with the agent itself, right? Did you see it happen? Did you talk with that person? Did you have any interaction? Because one of the parts that we haven't talked about is Wisconsin's what we call we have strict standards on what we call breach of peace. In other words, when the physical act of the repossession itself is occurring. And the case law is crystal clear. It's been around since the 90s. And if the borrower comes out and tells the repo agent, hey, stop, don't take my car, or no, you can't take my car, some form of an objection to the repossession while it's happening, that agent is required to stop the repossession on the spot. No ifs, no ands, no buts. And if they continue on with the repossession over that objection, they're going to get sued, and so can the lender, right? And so that's a real common one. The first thing that I want to talk with someone about is whether or not that occurred. If there was no interaction, there was no protest or something that occurred during the act of the repossession, then we're going to dive into those notices, right? That notice that comes out before the vehicle is repossessed. We're going to make sure we get a copy of it. We're going to make sure that the lender comply with both the timing and the content side. The reason these two things are important are this. Under the Wisconsin Consumer Act, again, those $25,000 or less loans, the remedies, the penalties to the lender are huge. If the lender violates the law, they're required to return the collateral or the vehicle to the borrower. The borrower owes no future payments on the loan. The lender is required to refund all of the payments made on the loan, and they're required to pay all of the attorney fees and costs for the borrower on that lawsuit. And yeah, you heard me correctly. They get a free car out of it. That's how serious this issue was in Wisconsin when they created this law and how it's been maintained since.
Are you seeing many of these claims and violations coming across your desk? So it's still happening today?
Yeah, I couldn't even begin to put a number on it. I've probably done 100, 200 of these over the past 10 years. I couldn't even begin to put a number on it. It's very, very.
I appreciate your time and want to kind of conclude, but if someone has a repossession issue or right to cure question or thinks their rights have been violated, is there a good way for them to reach out to you that you wouldn't mind sharing with them?
Absolutely. Yeah. They're always welcome to call my office. The phone number there is 414-377-0515. My paralegal's name is Ethan. So if you call there, the odds are you're going to talk to Ethan and he'll get us connected. We'll talk about what you've got going on and explore what we might be able to do.
I looked at your website before we spoke today, and there's just an amazing amount of information there on what we're talking about. And nice job with that. But what's your website address?
Sure. So it's the first four letters of my last name. So it's DELA-law.com.
Thank you so much. I can tell you that you helped me understand this issue a lot better. And as a lawyer that's been dealing with this for 30 years, it's an area that can be really confusing. And I'm just excited that we have this partnership with you that as our clients are running into these types of problems, we have an expert in Nathan DeLadurantey to help us. And I appreciate you. Thank you so much for your time.
Anytime. Glad to do it.